Good evening. This is John Milburn from Central Queensland University in relation to Laws 19038, Planning and Environment Law. It's week number 7, and we're dealing this week formally with the topics of regulation of land and resources, heritage and natural resources. The prescribed reading is chapters 8 and 10 of Jerry Bates' publication. As always, I've provided my critique in relation to the publications that are the prescribed reading, or at least chapter 8. Chapter 10 I'll defer until week 9 because it's dealt with in more detail at that stage, dealing with the issue of environmental impact assessment. Just a reminder that the assessment number 1 is due on the 7th of May 2015. That's at 11:45 p.m. As you would recall from previous sessions, I am very keen on ensuring that you submit your work on time. If you fail to do so, then subject to a cut-off, which is likely to be Saturday of the week after, then you will lose 5% per day for each day of late submission. If you do need to make an application for an extension of time due to extraordinary circumstances, bear in mind that it's not easy to obtain the extension in the first place. Secondly, it will need to be supported by some corroborative material in general terms. And thirdly, the application will only be considered if it is actually made before the due date. If the application is made after the due date, then it simply won't be considered. The assessment that I've asked you to complete for assessment number 1 is in 2 parts. Question 1 dealing with a review of a case, Predajon, and question 2 dealing with a number of different issues in relation to the more practical aspects of planning law. So issues to do with ecological sustainability, issues to do with the different types of strategic and statutory planning, the role of the Commonwealth through COAG. Just remember on that topic that there is the alternate link which I've provided to you through Moodle and UCrew. IDAS, we talked about that in previous sessions, the question of assessable development and how it's assessed and appraised, and the issue of concurrence agency and referral agencies. Of those, I think they're all relatively straightforward. You'll find most of the material in the text. Question 2, which deals with the issue of incremental strategic analysis and rational comprehensive planning, is something that you could probably find some good information on in relation to the study guides prepared by my predecessor, Dr. Lawson Smith. All right, so that's it for the first assessment piece. Now, I'm not going to rehash the material that's in Chapter 8 of the prescribed reading. Have a look at my formal overview in that regard. And the intention, of course, of those overviews is to provide you with my take on what I think are the most important aspects of that particular chapter. So keep that in mind. The topics that we're getting into now are really topics that relate to the way in which matters can be presented to a court in terms of the provision of expert evidence. So how the experts come to make decisions and provide recommendations in relation to such things as environmental assessment, etc. So I thought it appropriate to talk generally and perhaps more specifically about the role of experts, what they do, how they're engaged, how they're monitored and directed through the court system, and their role in that regard to the courts and not necessarily to the parties. So when it comes to environmental law litigation, a couple of, I guess, particular aspects that come to mind. The first is that environmental law and planning and environment law is a meld of both the legal and the scientific, in that the material which is presented is based on fact, but it's very much also based on opinions. And generally speaking, the rule is that opinion evidence is not admissible in a court of law, with the exception of the opinion of an expert. So hence, it is important, if you're going to proffer an opinion about a certain aspect of a development application, either advancing an argument for it or advancing an argument against it, that the arguments are supported by appropriate expert evidence, and that can be opinion evidence. So the sort of things that might be the subject of expert evidence would include provision of evidence about fauna and fauna, the effects of a proposed development on those things. It might be to do with stormwater management. It might be to do with architecture or amenities generally. Traffic planning issues can be the subject of expert evidence. Likewise, things like ecology. So experts can provide that very valuable opinion evidence to support a particular conclusion and come to a statement as to why that's the case. But experts have a much greater role in the provision of assistance generally to parties and then to the courts in the litigation sense. So when we talk about litigation in a planning and environment law context, we're typically talking about the developer versus either the concurrence agency or referral agency, the assessment that's been made, or the objectors that come in as third parties, generally speaking. So you've got those for and those against the development, or arguments about the conditions that have been imposed on an approval in relation to a particular development. So experts have a role at the preliminary stage by providing some general guidance to the party that has engaged that particular expert. And that will often, of course, occur well before any form of litigation, probably even well before any application is made or objected to. So once the expert has provided that general overview, that general statement of opinion, if the matter does progress to the development stage, if it progresses beyond that to the litigation stage, then experts have a much greater role to play once again. So experts, of course, would need to inspect the site and consider any scientific or anecdotal evidence which is presented to them in the form of a brief from the party that is calling the evidence or the expert. So it's very important, if you are a party associated with preparing a case, to ensure that the brief which is presented to the expert is comprehensive, it's accurate, and it simply asks the right questions. Because if you don't ask the right questions, you may not necessarily provide the evidence that you need to the court appropriately. So once the expert has inspected the site, considered the material, considered the scientific and other expert evidence, they'll typically prepare a report. But it's very common, of course, in a litigation sense, particularly in a planning and environment court sense, to have experts on both sides. Now, traditionally, the way that litigation was run was that a party would call all of their evidence, and that then would be the subject of cross-examination from the other side, and the other side would generally present its evidence, and experts were called on both sides, and the court asked to consider this whole scientific and expert opinion and ultimately come to its own conclusion. But in the planning and environment court context in Queensland, there has been the development of late of the Adr process, which has helped streamline the process considerably. ADR means Alternative Dispute Resolution. And in that regard, in the context of experts, the ADR registrar has a considerable role to play. Right, so let's say it works like this. A development application is considered by a concurrence agency or the assessment manager. It's refused or conditions are imposed that are not acceptable. The matter then goes to the Planning and Environment Court. The matter is the subject of pleadings, and there is a direction by a court. Now, the court is very likely to ask some questions about the evidence which is going to be presented. So the judge may say, well, what evidence do you propose to call? Who do you propose to call? What are the number of experts? What are the issues that you're going to call expertise on? Now, from that, the court will typically ensure that only one expert can be called on a particular topic. the court can give leave for more than one expert, but that would not normally be the case. So one expert per topic, and that's reflected in the Planning and Environment Court rules, and I'll refer to those shortly. So one expert per topic, but you've got to identify appropriately what are the topics that are in issue, who are you going to call expert evidence from, and on what basis. Now, if the other side also indicate that they're calling expert evidence, the court will want to see where there's some commonality in terms of the issues that are raised by that expert evidence on both sides. And rather than necessarily plough through all of the evidence on both sides, the court is likely to ask the parties to engage in a meeting of the experts, and from that meeting of experts, which is conducted in the absence of the parties, the experts will be asked or directed to prepare a joint report. Now, that joint report comes about as a result of the experts determining what are the appropriate issues for consideration, then proffering an opinion in relation to those issues, and identifying where there are points of agreement and where there are points of disagreement. In that joint report, the experts provide their opinions and make their statements as to why they believe a certain why the other expert is wrong, etc. So it's a matter of through that process coming up with some agreement and some identifiable points of disagreement. And you can understand that that will streamline the court process considerably as a result of going through that approach. Let's think about this in a practical sense, in the context of a developer wanting to have a development approved and being confronted with, say, objectors who are, say, environmental activists. In that regard, if you haven't already seen the Zoom video where I hosted Roger Curry, an environmental activist, I urge you to look at it because it really covers some very practical issues that we're talking about now in terms of the way in which environmental activists used expert evidence to ultimately secure wins in the P&E court. All right, so if you've got environmental activists, you're advising those people, we need experts. Now, you might become one of those experts that actually give evidence in a court. It's a great living if you do, and some very good money in it, but you need to establish your credibility in that regard. All right, so environmental activists generally don't have a lot of money, and there are some issues that they need to consider. The first is that at that directions hearing, if they believe that they have an expert who is good, but is not perhaps as experienced or high-powered, if I can use that term, as the expert or experts on the other side, then in those circumstances at the directions hearing, you might want to ask for an order that the ADR registrar actually convenes the expert conclave so that your expert doesn't feel overpowered or feel bullied in a certain way. So there's power under the Planning and Environment Court rules in relation to that type of order that can be made. So at the directions hearing, as I mentioned, the court will want to know what are the areas of expertise, what are the experts going to be called to establish, who are the experts in fact. So you need to be prepared for that if you're a litigant. If you are involved in the process of engaging an expert, just be careful not to colour the request with bias. The role of the expert, and this is really important, the role of the expert is to provide unbiased opinions in relation to specific issues in their expertise for the benefit of the court. So the expert's role is to assist the court, and its duty to the court overrides any duty that it has to their client. In other words, if the expert is of the view that something is the case, or this is the position, even if that's contrary to the opinion or interest of the party that's calling that expert, they must say it as it is, so to speak, and be truthful. That can be in the context of the joint report that I've talked about, or it can be in the context of their own statement of evidence, or it might be in the context of actually giving evidence in a courtroom. All right, so let's assume that the court has ordered that we have this meeting of experts. You might decide that you want the ADR registrar to convene and chair that meeting of experts, and if you do, there's power under Rules 24 and 25 of the Planning and Environment Court Rules 2010 for that to occur. They then prepare a joint report and identify the areas of agreement and disagreement. So the role of the experts is to provide opinion about the scientific and other expert material, which is the subject of the questions. They're not there to, I suppose, develop different options necessarily. That may happen, but their role is to comply with the brief and to bear in mind the responsibility that they have to the courts in that regard. All right, so the experts will come up with the report and come up with their own statement of report. If you're acting for a party that's perhaps down on funds, may have difficulty in raising the appropriate funds, then just bear in mind that there might be other ways to deal with the issue apart from calling an expert. It might be, for example, that they can call upon neighbours or other people in the area to attest to certain things. For example, that there is a quantity of fauna or flora in a particular area. It's not giving opinion evidence, it's actually giving factual evidence, and that might be sufficient. So you may not need to call an expert in that regard. Now, I've made mention of the role of experts in the context of the Planning and Environment Court rules, which are in 2010. In that regard, you can find those through the authorised source or through AustLII, and I'd urge you to have a look at that. So the Planning and Environment Court rules, they don't sound glamorous, but they're really important from a practical point of view. So Rule 22, for example, deals with the issue of who is or who is not an expert, why they can give opinion evidence as opposed to simply giving factual evidence, what is meant by this joint report which comes about as a result of a meeting of the experts, etc. Rule 23 talks about the fact that it is possible, and this is something to bear in mind at the early stages, it is possible to make an application to a court for certain things to be accepted and therefore not requiring the provision of expert evidence or proof to state a certain position. And that might be on the basis that it's going to cause a great deal of expense, really unnecessarily, to prove a basic point or to prove a point that's not really in dispute. So that's covered in Rule 23 of the P&E Court Rules of 2010. So in Rule 24 gives the court power to order or direct this meeting of experts and to have that meeting convened or chaired by the ADR registrar if need be. That's also covered in Rule 25. Rule 26 essentially imposes upon a litigant an obligation to ensure that their expert is ready to go and properly briefed in relation to the matters. And then there's Rule 27, which talks about the requirement to prepare a joint report. Now, Rule 28 is interesting in that when you have a meeting or a conclave of experts, the intention is that essentially we lock them in a room so they can argue about the scientific and other matters without the interference of the parties. So the parties aren't allowed. It's up to the experts to have this meeting and try and nut out what they agree upon, what they don't agree. Now, in the context of doing that, the experts may make statements about opinion or they may make compromises. The general rule is that those sorts of discussions are not admissible in court proceedings unless all parties agree that that is the case. So, sure, the experts can come up with a joint report, even if in that joint report they agree to disagree. that's all admissible, but that's not necessarily going to reflect all of the discussions and all of the compromises that were considered during that expert conclave. So the expert must prepare a statement of opinion through a statement of evidence, and that will generally be done in the form of an affidavit, or it might be in the form of an affidavit which has annexed to it the actual report. Now, when I talk about affidavits, I'm talking about sworn evidence, and not just from experts, but from anyone that is in a position to provide relevant information for the benefit of the court. Now, if you do obtain affidavit material and you file that affidavit material, that doesn't necessarily mean that the court will accept it, or that the other side will accept it. And very often, perhaps for the most part, those people that give affidavit evidence will need to attend at court as well. So just bear that in mind. Also bear in mind that while I'm making reference to the Planning and Environment Court rules of 2010, that's not the only set of rules that apply to litigation. You must also consider the Uniform Civil Procedure Rules of 1999, which have effect across all civil proceedings. And so P&E court proceedings are not immune from that, and you need to consider those as well. All right. Now, speaking of the court process, we've talked about the role of experts. We've talked about how experts might be engaged, what they might need to prove, how they interact with each other and with the courts. And ultimately, the courts make the decision. But there are some other important steps that I'll briefly mention as part of the litigation process. The first is that there is an obligation on parties involved in litigation to make appropriate, what we call disclosure. Now, disclosure is where the particular party or must disclose to the other side documents in their possession or control which are relevant to the case, relevant to the facts of the case. Now, there are some exceptions. For example, communications between the client and lawyers, that's exempt. That's privileged, and it can't form part of this disclosure obligation. So these are things that ultimately are disclosed, and they're put in a list of documents, so the court and the other side know that these are all of the relevant documents in the possession or control of the party. I mentioned briefly before affidavits. When you're acting for a litigant in proceedings, you need to gather the evidence, and that's not just from the experts, that's from anyone that is able to provide some information about the facts. And you would normally do that by way of an affidavit, or perhaps at least a statement. But bear in mind that you need to have those parties produced in evidence. All right, so the purpose of tonight's talk was really to tie in the fact that in Bates we're talking about a number of technical scientific issues now. We're also reading about cases where these things have been considered by courts, and the reason I want you to consider the Planning and Environment Court rules is to give you some insight into how these experts are engaged, how they relate to each other, and ultimately how they provide their evidence, which is then reflected in a decided case. So do have a look at particularly Part 3 of the Planning and Environment Court rules of 2010. You can find those through the authorised source or through Ostly, and also consider briefly, but not in detail, the Uniform Civil Procedure rules that apply as well. All right, well, thank you very much for your attendance. All the best for your first assignment assessment. I hope it all goes well. I'm looking forward to that. I think I'll have some excellent work coming my way, and I'll try to, what I'll do is limit the submission of work to the Saturday week after the due date. So that would be Thursday the 9th, by my calculations, the 16th of May, so that I can then provide feedback and results on Sunday the 17th of May. All right, all the very best. If there are any questions, please email, or better still, raise some issues through UCREW.